We have in earlier paragraph discussed the object of framing the issues. We also held that there could be several points directly or indirectly connected with the main issue that has been framed. In such cases, when the larger issue that has been framed is wide enough to cover different points of disputes within it, there is no necessity to frame a specific issue on that aspect. Further, when the parties go to trial with the knowledge that a particular point is at least had full opportunity to let in evidence, they cannot later turn back to say that a specific issue was not framed. All that is required under law is for the court to render a finding on the particular fact or law in dispute on the facts of the case. However, we make it clear that such evidence, in the absence of pleadings, cannot permit either of the parties to make out a new case. It is pertinent to mention here that the courts are vested with powers to go into the question of law, touching upon either the limitation or the jurisdiction, even if no plea is raised and not in cases where facts have to be pleaded and evidence has to be let in. The Civil Procedure Code and the law of limitation, being procedural laws meant to assist the courts in the process of rendering justice, cannot curtail the power of the courts to render justice. Procedural laws, after all, are handmaid of justice. What is to be seen is whether any irregularity arising from a failure to follow procedure has caused serious prejudice to the parties. It is not to be forgotten that the process of adjudication is to discern the truth.